This content is brought to you by Uphold, which is a great platform that makes it easy and simple for you to buy, hold, and sell and earn crypto. You can trade from anything to anything. For example, you could trade between cryptocurrencies and precious metals. It's an amazing platform that I've been using for years. And in fact, I still use to this day because they're one, a great exchange, they're reputable, and they're one of the only exchanges that still lists XRP. Many of the other exchanges have delisted XRP due to the SEC lawsuit, but you can still get XRP on Uphold. So I've interviewed the CEO, the founder, and many other representatives from Uphold over the years, and I'm a fan of this platform. And once again, there's some great features like trading between different assets very easily. You don't have to convert to a currency and so forth. They're used by 10 plus million users. They have over 200 cryptocurrencies and they have a very easy to use app. The interface is really nice. So I can certainly vouch for this platform. Once again, I've been a user for years. So if you'd like to learn more about Uphold, please visit the link in the description. Welcome back to the Thinking Crypto podcast, your home for cryptocurrency news and interviews. With me today is attorney John Deaton. John, great to have you back on the show.
Thanks, Tony. Thanks for having me as always, man. I appreciate it.
Well, John, I have lots of questions for you, and I know you're a busy man. You got a lot on your plate, but let's talk about the Ripple lawsuit. What's new? We saw summary judgment statements from both parties, the SEC and Ripple, and certainly want to touch on the amicus briefs from the Digital Chamber of Commerce as well as yours, and much more. Let's start with the summary judgments. What was your take on both?
All right. Well, just procedurally, so because I think there's some confusion out there. So what people need to understand is that a summary judgment is an offensive motion, right? It's offense. So Ripple filed a summary judgment motion saying that there's no reasonable jury that could ever think that they violate the law, neither should the judge, and the judge should just find that XRP is not a security as a matter of law. And they don't get into the fair notice defense. They don't get into any of that because it's just about the law, right? And the token and how it's not a security. And then the SEC and their motion for summary judgment, they're saying that they proved, and they cite evidence and stuff that they proved that Ripple engaged in this scheme starting in 2012, and that any purchase of XRP is violating the U.S. securities laws. And so they each file their summary judgment. And now we have to wait for Ripple to give an opposition to the SEC's. That's when you'll hear about the fair notice defense. Because if you look at the two motions right now, the only one that brings up fair notice is the SEC, because they have to address Ripple's affirmative defense, saying they didn't lack notice. But it's called a fair notice defense. So it's defensive. So Ripple will bring it up when they're defending what the SEC filed. And the SEC will write an opposition to Ripple's. Those are due around the 18th of October. And then each side gets to do a reply, right? So Ripple moved for summary judgment. The SEC opposes it. Ripple gets to reply to the SEC's opposition. Same thing for the SEC. They filed their motion. Ripple opposed it. They get to reply. Those replies are due somewhere around, November 7th to the 15th, somewhere in there in November. I don't have the dates memorized. So all of the briefing will be completed by mid-November. And that's when the clock begins to tick on how long will it take for Judge Torres to write a decision and a ruling. Okay. Mm-hmm. And so that's sort of the procedural landscape that's happening right now. Ripple's summary judgment motion, I've stated before when it first happened that it's a brilliant argument. in many ways, I hate it because, it's not like red meat. It's very much about the law and how the Securities Act of 1933, what they meant, and they incorporate all the different state laws around the different states of the country that help form that statute. So they're getting into a lot of statutory intent and things. That's why they cite things like the pre-1933 blue sky laws, right? Stuff that, normally you don't hear of.
Wow.
And Ripple's argument for summary judgment is that in their research, that you have to have a contract before anything else. And there has to be, it's called an investment contract, that you have to have a contract. And before you even get to the Howey test, if the judge doesn't find an underlying contract, you don't even get to Howey. And then they say, well, Judge, if you disagree with us, you find that you disagree that we don't have to have an underlying contract. Well, you should find for, because the 4 factors of Howey don't apply to XRP. There's no common enterprise. XRP holders didn't rely on the efforts of Ripple. We win that way. So that's basically Ripple's argument. The SEC's argument, I got to tell you, I was proven wrong about something, Tony. I actually predicted that there would be more damaging evidence against Ripple that we didn't know about. Because we're not privy to depositions and the documentary evidence, any of that. And so I figured that there's going to be a couple of things that might be a couple bad days for Ripple publicly, right? The people would take shots at it. The haters would be able to cling on something. And I was shocked because it's really not there. There's no there, so to speak. And it basically is a marketing case against Ripple, right? Because Ripple sold XRP. They sold XRP to accredited investors, to venture capitalists, and they sold it on exchanges to the public, right? That's a fact.
Yeah.
Brad Garlinghouse, Chris Larson sold. And so the SEC is basically saying they're going with a different argument. Ripple's saying you have to have a contract, then you apply Howey. The SEC is going to argue that you don't need a contract, that the language of Howey is that a contract, transaction, or scheme equals an investment contract. And they're going to cite case law for that. And they're going to say that it's the scheme, that even though there's no contract between XRP holders and Ripple, that Ripple devised this scheme to create a secondary market and to sell XRP, give it away to some people, get selling going, establish liquidity. And they didn't have a use case, and they didn't get a use case until 2018 with ODL. And then they sold that to fund their business, their very ambitious business. And the problem with the SEC's argument, though, is that they had to concede during the litigation that Ripple owes no obligation to XRP holders. And that you owning XRP, Tony, you no claim to Ripple. And Ripple could stop using XRP and decide that Bitcoin is the coin of choice, and they're going to use Bitcoin for their ODL. And they're never using XRP again. You and me as an XRP holder, we've got no claim, right? We can complain if we want. It means so. What's missing in the SEC's case is that issue, which means where's the common enterprise? The common enterprise in the complaint was Ripple, that we are investing in XRP because of the management team of Ripple, and we're in a common enterprise with Ripple. And now that that's out, that there's no obligation, there then went with an expert witness who said that the entire XRP ecosystem was the common enterprise. That would mean you, me, Coinbase, when they listed it, Uphold that listed today, developers around the world, everybody is part of this ecosystem, and we're all in it together. And so that's the common enterprise. But I know I'm going a long time, but they didn't rely on experts. And that's something I do want to talk to you about. Sure. They didn't rely on any experts. So now, what is the common enterprise? And I won't be surprised if we see in their other papers that the common enterprise, and this would come in their reply in November, is the XRP ledger, right? Because we all sort of have this interest in the XRP ledger as the native XRP being the native token. That's absurd because that's a software network. How is a software network a common enterprise? But that's basically an overview of where we stand with the summary judgments. So
to your point, there's still a lot of procedural things that have to happen. There's certain specific dates. It's October 18th, and then subsequently in November. And then this thing could potentially wrap up next year, right? Based on the updated facts, are you thinking we see some sort of conclusion sometime next year?
Yeah, unless there's a settlement, there will be no decision before the end of this year. All right. I'm confident in saying that it's never going to happen because the briefs and everything's going to be due, say, mid-November. And then the next week you got Thanksgiving, and then you got Christmas, and you got holiday season. And it's just never going to happen. And even if there weren't any holidays, do you think Judge Torres and her clerks can put together a decision of this magnitude in 6 weeks? It's just never going to happen. Yeah. So people got to get that out of their mind. If there's a settlement, fine, right? That's one way that it resolves. But if it does not settle at all, if this case never settles, then the earliest, and I know it's bad news, man, but the very earliest that I would expect it would be the end of March.
Okay, of 20.
But there's a good chance, and even Brad Garlinghouse, and it's got to be based on what his lawyers are telling him. Brad Garlinghouse said, "Look, I've been told this takes between 2 and 9 months." So I won't be surprised, absent a settlement, that May 1st comes and we're still waiting.
Sure.
So people just gotta
yeah,
accept that reality. Maybe it resolves and settles, and we don't got to worry about that. But we'll see.
Yeah, it is what it is as far as the timeline. So if there is a settlement, and I know this is a bit of speculation, what do you think that looks like? Is Ripple paying a fine for 2013, 2015? XRP is free to then be relisted on exchanges, things along those lines?
Yeah, at this point, Stuart Alderati, who's the general counsel of Ripple, Brad Garlinghouse, the CEO of Ripple, they have both now publicly said on more than one occasion that they won't settle unless ongoing and future sales of XRP by Ripple or anyone else in the secondary market are not considered securities. So the problem with the settlement, Tony, is that it would require the SEC to agree to some kind of statement, right? It could be in writing, it could be publicly announced, but they would have to agree that moving forward, XRP is not going to be considered a security. And the SEC doesn't like to do that, right? Except for Bill Hinman, right? The SEC normally doesn't like to kind of give that kind of clarity to one token, allegedly. The problem that I see is more of a political one, which is you sued Ripple saying XRP is a security, including secondary market sales. And then you want to go after all these other cryptos. How do you reconcile saying XRP is not a security, but XLM is. XRP is not a security, but Algo is. XRP is not a security, but ETH today is, right? And so I'm not saying be done. I'm just saying that is a very narrow, like you got to thread the needle on that one, man. Sure. To figure out how you can publicly do this and then still be able to go after, other cryptos. And so I haven't changed my mind, Tony. Without the pressure of the Hinman emails and the documents that need to be turned over, if the SEC is not forced to do that, I don't think they settle. I know people disagree with me, and that's fine. You said it best. I'm speculating. I've always made it clear that just because I'm amicus counsel, I don't have any more insight. Your guess and speculation is just as good, just as valid as mine. My opinion is it will not, unless Gary Gensler is forced, right? Because a lot of people think that, well, he won't risk a judgment because it hurts him against other crypto. And I understand that. I've said that myself at times. But we go back to, how does he say XRP is not a security, but the other ones are? It's a very delicate situation. But, I did a tweet today where a lot of people are thinking, oh, Ripple's going to win for sure because of their initial brief. They don't even get to the Howey test. That doesn't mean the judge is going to agree with that. Sure. Right? That's a very, very, very novel concept for today, and it would mean that she has to disagree with Judge Castell and Telegram and other appellate judges, and she would have to disagree with them and agree with Ripple, and she might not. And so, I think that XRP holders, because we feel confident, you can't get blinded by your bias or your emotion or your passion or your conviction. And so, but if Gary Gensler's told by the judge, you've run out of appeals, can't go to the Second Circuit, your writ of mandamus has been denied, you have 10 days, and let's say it's December 1st, you have 10 days to turn over all those emails, all those comments, all those drafts. And if in those drafts and in those comments are discussions of XRP, why isn't XRP being given a pass? Hey, if you're saying it about ETH, you say it about XRP. I'm not saying that's in there, but I believe there's going to be somebody, right? Somebody's going to say, what about XRP? If that's in there, and even if it's even better, that could be a guaranteed victory for Ripple. And that's when they say to Gary Gensler, we're definitely losing. And so settle today, see if you get 50 million. And we're just going to have to say that XRP is not security. We'll figure out a political way to do it, still go after the other ones. But you'll be able to go on thinking crypto and say, I enforced the securities laws and I brought Ripple, to the table, and I forced them to acknowledge their wrongdoing between 2012 and 2017 or whenever. They paid 50 million, 100 million, whatever it is, 25 million. And I'm forcing this issue because these tokens violate securities laws. He could spin it into a win. But until he's placed in a political quagmire, that you're definitely going to lose, Gary, you need to settle. We don't want these documents turned over, Gary, because they say some shit we don't want the public to know.
Yeah.
Right. Until something like that happens, I think he's okay with going to judgment, man, because listen, at MIT, he's on video saying it's for a court to decide. If the executive order leans towards the CFTC, if the Loomis bill leans toward the CFTC, if the bill that's in the House leans toward the CFTC, if he sees that the political momentum is to the CFTC anyways, Well, he might be willing to roll the dice, and maybe he gets a verdict, a judgment in his favor. He can turn around and say, look, I told you it was a security. And if XRP is a security, then they're all securities. Gary Gensler, Tony, would sound like you and me. You and I and others in our community have been saying to the rest of the world, look, if there's a judgment and it is deemed that XRP, today's XRP, is a security, then almost every altcoin is. You know, maybe not Litecoin, maybe not Doge, they're Bitcoin forks, right? Maybe not, but ETH certainly is. XLM certainly is. Yeah. You know what I mean? Algo certainly is, in my opinion. Cardano, they're all going to be implicated. And so that's sort of the way I look at potential settlement.
Let's talk about the amicus briefs. Obviously, you're a friend of the court representing 70,000 plus XRP holders. Recently, the Chamber of Digital Commerce filed their respective amicus brief. I spoke to the lawyer earlier today, and I would love to get your take on your respective brief, the Chamber's brief, and then potential others entering into this mix.
Yeah. I believe there's going to be, if I had to predict, I'm not going to necessarily say who, because I don't want to, out somebody and then they don't, and then I look like a dick. And so, but if I had to predict, I would say, in addition to the one I'm going to file, there's going to be at least two others, which would be 4 amicus briefs being filed in this case. And so I think people have accepted now. 2 things are why I believe that. One is finally, Tony, what you and I and the XRP community have been saying to the rest of the crypto world since December 22nd, 2020, that the SEC is coming after crypto.
Yeah.
And, don't just let them say this is just an XRP thing, right? You've been preaching this, I've been preaching it. I think they see that. I mean, the day after the merge, the day after, Gary Gensler all of a sudden implicates the merge. It says that, quote, the proof of stake merge could implicate securities laws. And then a week later, we see in the suit against the influencer or whoever, the argument that the SEC has jurisdiction over all Ethereum transactions.
Right. That was the Ian Molina lawsuit, yeah.
Yeah, but because of the nodes being 40%. But Tony, what does the SEC have jurisdiction over? Securities.
Yep.
So if the SEC says that they have jurisdiction on ETH transactions, what are they saying? They don't have jurisdiction over commodities.
Right.
Right? I mean, that's as close as coming out and saying, I'm coming after you as it gets. And I think that because of that, right, people now accept Gensler is trying to kill this market or crush it to the point that the incumbents can come in and get it for dimes on a dollar, right? Hey, crush an exchange, maybe Goldman Sachs comes in and takes 25% or 49% of an exchange, and now they're in whatever. And then all of a sudden, when those incumbents are in and have a bigger slice of this pie, then all of a sudden we might see Gary Gensler say, well, crypto is a great innovation, and we're working with the entrepreneurs and technologists, and we're going to come to a decision. And then all of a sudden, whatever crypto's blessed, say it's ETH, right? Or XRP, doesn't matter. It'll become the investments of a lifetime.
Yeah.
Right? Because who has the big slice now? So I just think that they see that. So I can't imagine that they're not going to I just think that the blinders are off. This isn't just about XRP. This really is an outrageous, unconstitutional, unlawful government land grab for this industry, and we have to do something about it. So that's why I think there'll be others. You know what I mean? Listen, I love the XRP holders, and God bless them. To be honest with you, they defend me because they appreciate the work that I've done, and so, I see tweets out there of like, but Deaton's been here from the beginning, whatever, and then they like, too late. And I take the opposite of you. Like, let's just, we got to get past the tribalism. We got to get past any of that. We have a common enemy, right? And we want technology to flourish. Yeah. And let the winners be the winners. And, if ETH flips Bitcoin, let it happen. If Bitcoin takes 80% market share, let it happen. If XRP flips ETH, and that's the way the market says, let it happen. And let's, put all our energies against them. So I welcome that. I was very happy and thankful. I DM'd Perry and Boring. It's like, great job. Thanks. It wasn't Bruce Willis looking out the window saying, "Welcome to the party." Right. It's sincere saying, we want that. And they made good points, and it's going to be very different than what I file.
Sure.
Because for one, we have been in this from the beginning, right? We are amici counsel. Amici. Mm-hmm. We don't have to ask. I still have to ask for permission for her to accept my brief, sure. But we've been designated. So it's going to be different. I am taking a position, the Digital Chamber of Commerce is more as like, Judge, we're not taking a position for Ripple, against Ripple, for the SEC, against, but we want you to be very concerned with your language. That's really what they're saying to the judge. Like, please make sure that there's a difference between, the underlying asset and an asset that can be used, right? And basically what they're saying is that, and I'd be interested, I know you just interviewed the attorney, but they're basically saying in so many words, more articulate than I'm going to right now, that, hey, anything can be used as a security, right? Oranges, chinchillas, whiskey, Bitcoin's been used, beavers have been used, any kind of asset. It's all about, the way you package it, market it, offer it, and sell it. And so don't focus on the token, focus on how it was offered and the how. And that's important, because the more the judge hears that, and I'm going to say that too, of course, but I'm taking a position, right?
Sure.
But to some XRP holders' surprise, I'm not taking a position on Ripple. Like, I'm not going to say Ripple didn't sell a security.
Yeah,
that's not my job. They got better attorneys, right, to do that. I'm focusing on you, right? I'm focusing on me. I'm focusing on your mom that I know that bought XRP, and I'm saying to the judge that we need a declaration that secondary market XRP that is traded is not a security. As a matter of law, it's not a security. And sure, is it possible that Ripple could have sold it a certain way many years ago? Okay. If they prove the case against Ripple on that day, that transaction, fine. Yeah. But they're trying to say, and they do say, any purchase of XRP is a security. You see, and that's still saying that XRP is a security.
Right.
If any purchase, if that's their words, any purchase of XRP was an investment in a common enterprise where we expected to profit from Ripple's efforts. That's what they're saying. So they use the words any and all. Any purchase, all XRP. So I'm trying to get her to really distinguish that and make it clear, and also, other things. So I wouldn't be surprised if other amicus come out and they're more aggressive. You know what I mean? The Digital Chamber of Commerce, they could have been a little more aggressive, but I don't, and that's not a criticism, that's an observation.
Sure.
But I think that they're holding themselves out to, like, listen, this isn't about a company, right? We're not here to defend. We're here to defend the industry from being, the assets being overclassified or categorized in the wrong way, and we want you to be aware of that. And so it's good. I'm very happy that they did it.
Now, I want to circle back to Ethereum, because a lot has changed since Bill Hinman gave a speech that Ethereum is not a security. Obviously, you had the merge, the move to proof of stake, entirely different protocol going away from proof of work, which Bitcoin uses. And then you have Gary Gensler, Chair Gary Gensler, not reiterating the same statements that Bill Hinman and Jay Clayton and Commissioner Jackson all said, that this speech was great. It gives an example of how we're viewing the asset and so on and so forth. He refuses to talk about Ethereum. He just talks about Bitcoin. So, and once again, I hold Ethereum. I don't want Ethereum to be classified as a security. And my thoughts around this is, it seems like Gary Gensler is preparing, and to your point of, what was outlined in the Ian Bellina lawsuit of all transactions on the Ethereum blockchain under the SEC's jurisdiction. Are they looking to now say Ethereum is a security? It seems signs are pointing that way.
I believe so, but I also believe that they're going to sue, an exchange. I think they're going to sue Coinbase. They may see Coinbase and Kraken and FX all together. You know what I mean? Or it could be individual. Listen, I have to resist that temptation to be like, I told you so, all that shit, right? I don't want to do that because there's no need. But, if you go back to a video I did a year ago, I said that ETH would be implicated. If Ripple loses and if XRP is deemed a security, ETH will be implicated. And you can't rely on what one guy said, when the official position of the SEC is that they don't make official positions. Yeah. And, if a Republican becomes president in 2 years, Gary Gensler's gone. And that new chairman will think ETH is a commodity, right? Might think XRP is a commodity, whatever. And so these are political appointees who have agendas. And my feelings on Bill Hinman's agenda. I think it was a personal agenda. Yeah. All right. But that doesn't mean it ties Gary Gensler's hands. And what I warned people about was that they say, oh, the statute of limitations passed because the ICO was 2014. When's the new statute start beginning to run? Merge, right? If you go back to Bill Hinman's interview, I would tell people, and I tweeted this out, he gave his speech, and there's some qualifiers in that speech, but in his interview, he said, I'm just telling you, if you set aside the fundraising, today's ETH is not a security. That doesn't mean if circumstances change. He literally said those words in an interview, right? That doesn't mean if circumstances change, maybe it would become a security. So yes, because I think there's a fundamental thing that Gary Gensler doesn't believe. Mm-hmm. Hester Peirce, Robert Jackson, Jay Clayton, Bill Hinman. I know those four for sure. Elad Roisman, those five. They believe that an asset can start off as a security, but then over time, it no longer would constitute a security. And the securities laws, the policy behind them doesn't apply because they become sufficiently decentralized, right? Jay Clayton agreed with that in the letter to Congressman Ted Budd. It's the Bill Hinman speech says that. Hester Peirce's whole safe harbor provision is based on that concept that, hey, it could start off as a security, right? We could say that about XRP. When XRP was first sold and there was no other developer on the XRP ledger and there were no other XRP holders, that first transaction, if that investor just sat back, right, and relied on Ripple, could be a security. Now, it may be exempted because it's an accredited investor and all that, but I'm just saying that you could make a good argument that that's a security. But then, you know, as I say to people, 2013's XRP is very different than 2022's XRP.
Right.
2013's XRP ledger, very different than 2022's XRP ledger. And so if you go back to Gary Gensler on my crypto law site, we have his MIT videos, and I used it from, you know, the community, where he says a bunch of venture capitalists went into the SEC to argue that this transition, and he says, quote, I don't think it's going to work. There's no case law that supports an asset changing. I think Gary Gensler believes once a security, always a security, and that's his fundamental approach. And so the proof of stake, why would he implicate it? I mean, right after the merge. And so I think that, and like you, I own ETH. And I say to the XRP holders, you know, it's tough because the XRP holders, if we're going to end tribalism, like Brad Garlinghouse says, you know, you have to resist the temptation of, no, you come. Now you're getting sued, right? And there's a difference between suing executives who may have broke the law. There's a difference from wanting an investigation into the conflicts of interest and all of that. I support all that. But just like Brad Garlinghouse said, I don't believe that today's ETH is a security because I don't believe the way the SEC applies the securities laws. Right? Do I think it became more centralized than XRP? Yes. Do I believe that proof of stake because the more tokens you have, the more weight you have? Like, those are all issues, but I still don't believe it meets the technical legal definition of an investment contract, today's ETH. So I don't want to see, you know, the SEC claim today's ETH is a security. Right. And to my XRP holders that I love, man, I would just say, listen, there's innocent ETH holders out there. Yeah. You know, there's somebody who doesn't give a crap about Vitalik and what he said. Who doesn't
My
even
mom has ETH in her portfolio.
Yeah, there you go. Like,
doesn't know who Vitalik is.
Does she know who Joe Lubin is? No. Right. So your mom, I go back to your mom, man. Yeah. Your mom is that innocent XRP holder, innocent ETH holder. It's not good for crypto, right? For them to say, well, we're just going to erase the last, 5 years, and now ETH, everything's a security. And so, but as usual, the onus is on the XRP holder to take the higher road and be like, and I know there's people that support me and they'll be like, John, I love you, but fuck that. I want them. I want revenge, right? I mean, I get it. But I just want to see this space foster, right? And somebody's got to stop pointing the finger. You know what I mean? But listen, Vitalik wants to tweet again that XRP holders don't deserve protection. I'll go after him again. Like, sure. I mean, I'm not backing away from anything I've said or done. I'm just saying that let's target the people that deserve investigations or deserve, inquiries versus the moms who own ETH, Bitcoin, XRP, little algo, maybe some quant, whatever. You know what I mean?
Yeah, and I know a lot of people, to your point, one, I'm not going to name names, but like a family friend, she just loves like trading, and she's like, I do it on the train, I'm going home, but she could care less who the hell, Vitalik is or who did what. She's like, I just want to flip it and make money. Okay, well, but she
Yeah,
doesn't know anything.
that's called commodities trading.
Yeah.
Right? She's a commodities trader, right? She's trading Bitcoin and ETH and XRP or anything else, and maybe who you're thinking of, maybe she made some good money on that run up of XRP from what 35 cents to 55 or whatever it was. You know what I
Yeah.
mean? I wish I was a trader. I can make some money, but the first time I sell, it'll go to the moon. Right.
So I want a last item here before I let you go. I want to ask about LBRY. What's happening there? It seems to be a delay in decisions there.
Well, I think we expected a result by now. The trial date is technically, if there's a trial, would be October 3rd. But as I said to other people, if the judge, and he said this in the oral argument, he said, a jury, we probably don't want a jury to decide this, which sounds like the judge is going to say what Ripple wants and what the SEC want. In their case, they want the judge to make the decision. So if there's not going to be a jury trial, then that October 3rd date, the judge can do what he wants. It could have come out while we're talking. Like we'll see. And if it's, I'm hoping that, I hope LBRY wins outright. I don't think that's going to happen. I just don't want them to lose outright, right? I want to see the judge say, okay, the token's not a security. This one sell to some investment club, that particular sell, they put it in cold storage and they sat on, that meets that, you can do all that and say this specific sell but then say that, use language that is helpful. Because obviously, if the SEC were to outright win, it doesn't mean the judge Torres is going to agree with the judge in New Hampshire, because it's different laws, different circuit. Believe it or not, different interpretation of Howey in New Hampshire in the First Circuit, right? They interpret Howey a little bit different than the Second Circuit and the Fifth Circuit and the Ninth Circuit, and so. When things get up to the Supreme Court, it's when you'll have differencing of opinions between the circuits, right? And then the Supreme Court will say, okay, we're going to settle this. The First Circuit says, this, the Second Circuit says that, we're going to decide it, and then they take the appeal. Before we go, though, I do want to, because I know a lot of people watch your show, and I want to say something I said on Twitter. I want people, and I know this goes to you because you've been a participant in all of this, but XRP holders have impacted this case significantly. And I'm not just saying that, Tony, because, I've been a part of it, but remember, the SEC's summary judgment motion does not rely on any expert witness. Right. And I'm sure you remember all that litigation about the one expert who was going to say what your mom thought when she bought XRP or what you thought. Right. Remember, I'm not going to name his name, but he became his expert one.
Right.
The SEC tried to throw me off the case because I used his name and I did some mean tweets. Remember all that?
Yeah.
Well, I filed a motion saying to the judge, hey, we should be heard, and I should be able to write a brief on this expert if he's going to talk about what my people that I represent, what they thought, right? Because I think he's full of shit, right? It's going to be like the legal technical way to say it. Right. Well, the SEC abandoned that expert, did not rely on it. So, and part of the reason is, we collected over 2,500 affidavits, sworn affidavits from people like you, XRP holders, who said, look, I bought XRP first day, never heard of Ripple, never heard of Brad Garlinghouse. I bought it because I first bought Bitcoin and it took like 15 minutes. I thought I did it wrong. Then I bought XRP and oh my God, it was there in 3 seconds. And I was like, this technology is great. And You know what I mean? Or I use the ledger, or I use the DEX, or I'm a YouTuber and I received some of it as tips and for content, and I didn't use it as an investment. I bought a new microphone, whatever, right? Like, just we participated, and I didn't send it to the judge, but I sent those affidavits to the SEC and to Ripple. And so if the SEC would have relied on that expert, we gave Ripple all that ammunition, right, to challenge him and to get in all of that stuff. And so the SEC tapped out. And so that's a huge win for XRP holders, because in the summary judgment, and I'll highlight this in our brief, Tony, they don't offer any evidence about what we relied on, right? They say Ripple put it on their website, how to buy XRP. Well, guess what I can say? Here's a CNBC article on how to buy XRP.
Right. It was a video, I remember.
There's a video, right? I'll cite to the video, right? That's what I'm saying is so you can't prove that Tony's mom bought XRP because they say because Chris Larson tweeted something positive in 2014. I wasn't even on Twitter in 2014.
My mom doesn't know who Chris Larson is. She doesn't know what Ripple's website is. She was just asking me, hey, I want to get into cryptocurrencies, buy me the top 5 or something.
Yeah. And many of the affidavits were people saying, listen, I wanted to diversify and I picked the top 3.
Yeah.
What you just said, pick the top 5. So I bought XRP. My daughter, Jordan, is on there, right? My daughter didn't know. She knew that her dad was talking about cryptocurrencies, the 4th industrial revolution, girls, right? I had my daughters in high school in 2016 do a debate on Bitcoin, right? And so because I was getting into it. So my daughter was like, when she got 15 grand, when she was 18 years old, she goes, my dad's always talking about crypto. You know what? I'm going to just buy 1 Bitcoin for 10,000. It was 10,000 at the time. And I'm going to take 2,500 and buy ETH and XRP. That's it. That's all she did. Like, she knows nothing about the technology. She knows nothing about the company Ripple. And, whether that's smart or not smart, that's not the point.
That's not the point.
Right? The point is she didn't rely on them. She was doing that. And so there's developer affidavits about developers, independent of Ripple, spin the bits, stuff like that had nothing to do with them. So it's just because I want them to know that taking the time, taking the effort, being willing to put an affidavit and put your name on it, because a lot of people are like, I don't want to highlight myself. I don't want to, they took a stand.
Yeah.
They fought back. And they need to be proud of themselves. And so it had a huge impact. That's what I'm saying. So,
yeah, that's amazing. Amazing to hear that. And that, look, I know a lot of people, it's been painful, right? After the lawsuit, and they saw their portfolio value go down, and they've been trying to amplify their voices. And it's great to hear that their voices are having impact. And that's
really it is cool. Absolutely. And we're still, it will more, because, when we get off this video interview, I'll start going back to the brief.
John, always a pleasure, and as always, thank you so much for what you're doing.
Thank you, Tony. Appreciate it.